So you have learned about the union executive in great detail. Let's move on and learn about the state executive. So like you have a parliamentary system of governance at the center, a similar structure has been envisaged by the constitution for the states as well. So the state executive comprises of four actors: the governor, the chief minister, council of ministers, and the advocate general. So the provisions related to state executive is contained in part 6 of the constitution, and the relevant articles are articles 153 to 167. So first, let's learn about the governor. So Article 153 says that there shall be a governor for each state. So the governor is the executive head of the state, like the president is in the case of the union executive. However, please note that at the center you have a post called the president and you also have a post called the vice president. When it comes to the state executive, there is no such post such as vice governor. There is only one post of governor. So the 7th Constitutional Amendment of 1956 made it possible to appoint the same person as the governor of two or more states. So the same person can be appointed as the governor of Karnataka, the same person can be appointed as the governor of Rajasthan, the same person can be appointed as the governor of Orissa. So this has been made possible by the 7th Constitutional Amendment of 1956. What makes the governor's post special is that he is not elected directly or indirectly. Rather, he is appointed by the president under Article 155. So this might lead to a certain assumption that, oh, he is appointed by the president, which means that he is employed by the central government. That would be a wrong assumption. Just because he is appointed by the president, please do not be under the assumption that he is an employee of the central government, and this has been clarified by the court in the case of Har Govind versus Raghukul Tilak, which is a 1979 case. So the post of governor is an independent constitutional office. It is not subordinate to the central government. So in the draft constitution, they actually wanted the governor to be an elected official. However, there were certain reservations to the same. Why is there a post of governor? Because we need an impartial head in the state. So if governor is also an elected official, which means that he'll have some sort of a party affiliation, which automatically makes him not impartial. Secondly, there is already an elected head in the state, which is the chief minister. So if you have another elected head, that could lead to a lot of clashes. Thirdly, it does not make much sense to spend public money on the election of an executive nominal head. So these were some of the reservations that was there with respect to making the governor an elected official. So we discarded the American system wherein governors were directly elected by the people, and instead of that we adopted the Canadian system where the governor of a province is appointed by the governor general. So yeah, that is the background of the post of governor. Moving on to the qualifications of governor, as you must have observed in other cases, here also there are no educational qualifications mentioned. It's not mentioned whether he should have a certain level of education or he should have done this particular degree. Nothing of that sort is mentioned. Only two things are mentioned. One is that he should be a citizen of India. Secondly, he should be above 35 years of age. Certain other conditions are mentioned. One is that he should not be a member of parliament or any state legislative assembly or any state legislative council. Secondly, he should not hold any office of profit. Now, what amounts to office of profit is something that the central government and the state governments can decide from time to time. So essentially, governor should be someone who is not having any other sort of a commitment. His only commitment should be towards the state or the states that he is appointed as a governor for. And the emoluments, the allowances, and the privileges of a governor is decided by the parliament. If he is appointed as a governor for two or more states, then all of his expenses will be distributed among these states. They will take care of such expenses, but it will be distributed among those states. There are certain conventions followed while appointing the governor. So, conventions are general practices which are followed while appointing a governor. These are not provided under the constitution. However, these are certain conventions. Firstly, usually an outsider is appointed as the governor, which means if a governor is to be appointed in the state of Kerala, usually, someone who is not from Kerala will be appointed as the governor of Kerala. Why? Because this person will be free from any influence of local politics. Secondly, the president usually consults the chief minister before appointing the governor. So, these are two conventions that are followed while appointing the governor. So, a person who is appointed as the governor of a state will not be liable for any decisions taken in his name. And very importantly, he can claim immunity from criminal proceedings. This does not mean that a governor can commit any kind of a crime and get away with it. It only means that as long as he is in office, as long as he is holding the post of a governor, no criminal proceedings can be initiated against such person. So what has to be done? Firstly, he will have to be removed from the office, removed from the post of governor, then criminal proceedings can be initiated against him. So if there is an accusation of murder against a governor, this is a procedure that has to be followed. But please note that there is no such bar with respect to civil proceedings. So even while a person is in office as a governor, civil proceedings can be initiated against him, but he can claim criminal immunity from criminal proceedings during his term. So let's learn about the term of a governor. Now this is provided under Article 156. So a governor is appointed for a period of 5 years. However, this is subject to the pleasure of the president. Now this term is very important, this phrase, the pleasure of president, which means that the president has the power to remove a person appointed as a governor at any given time without giving or without providing any reasons for doing so. So this is a tricky and a controversial topic. Why? Because the president, once he is elected as the president, he is bound to act on the aid and advice of the Council of Ministers under Article 74. So in effect, it is a central government that is appointing and removing governors. It's not like the president himself is taking such decisions. It is always on the aid and advice of the Council of Ministers. So this is why this is a very tricky and a very controversial topic. In 1989, when the National Front government led by VP Singh came to power, then President R. Venkataraman sent a message to all the governors back then asking for their resignations. Later in 1991, when the Narasimha Rao government came into power, they removed several governors appointed by the VP Singh government. So the Supreme Court in BP Singhal versus Union of India, which was a petition challenging the removal of 4 governors from Uttar Pradesh, Gujarat, Haryana and Goa. So in this case, the court observed that the president, in effect, the central government, has the power to remove a governor at any time without giving any reason and even without providing this person or granting this person an opportunity to be heard. So there is no such condition laid down by the constitution that before removing a person who is appointed as a governor, an opportunity shall be granted to such person to make a case as to why he should not be removed. No. President says you shall be removed, then you shall be removed. That is the procedure. However, the court has observed that this power cannot be exercised in an arbitrary, capricious, or unreasonable manner. The power of removing governors should only be exercised in rare and exceptional circumstances for valid and compelling reason. So, even though the president is not required to provide any reason for his decision of removing a particular governor, such action shall not be unreasonable. It shall only be exercised in rare and exceptional circumstances only when there is a valid and compelling reason to do so. And the court also observed that just because a governor is at variance with policies and ideologies of the central government, just because a governor, might have a different political lineage, or he is, leaning towards a different kind of a political party or an ideology, just because of that, a person shall not be removed from the post of governor. So, a change in central government is not a sufficient ground for removal of governors, is what the court has observed in this case. Several commissions over the years have also tried to bring some sort of a change to this particular provision, to bring more accountability, to bring more stability to the post of governor. So the Sarkaria Commission of 1988 recommended that the governor must not be removed before the completion of their 5-year tenure, except in rare and compelling circumstances. The Venkatachalaya Commission of 2002 similarly recommended that ordinarily governors should be allowed to complete their 5-year term. If they have to be removed before completion of their term, the central government should do so only after consultation with the chief minister of the particular state in which this governor is appointed. The Panchi Commission of 2010 on center-state relation suggested that the phrase during the pleasure of the president should be deleted from the constitution. So several suggestions have been made over the years. However, none of these were incorporated and the provision remains the same in the constitution. Now let's see what are the different powers of the governor. So governor has executive powers, legislative powers, financial powers, judicial powers. We'll not discuss all of these powers in great detail, but we'll have a look into these powers in brief. But most importantly, please note that the governor does not have any kind of a military power like the president. President is the supreme commander. However, here the governor has no such powers. So, coming to executive powers, all executive actions in the state are formally taken in his name. So, all administrative actions and executive actions are taken in the name of the governor. And governor has the power to make rules in the manner in which such orders or other instruments which are made and executed in his name will be authenticated. That is one of the powers of governor. Governor also has the power to make rules for convenient transaction of businesses in the state. So in the state there are several types of activities that has to be taken care of, right? There are agricultural activities, transport, electricity. There are many different profiles of ministerial activities. So the governor can make rules with respect to convenient transaction of such businesses, and he can also make rules for the allocation of such businesses among the ministers in the state. The governor appoints the chief minister and other ministers, and this is provided under Article 163. However, once the governor appoints a chief minister, the roles become sort of reversed, and the governor would not be able to take any decision without the assistance and aid of the chief minister. The governor also appoints the advocate general of a state and determines his remuneration. The governor also appoints the state election commissioner and determines the conditions and services and tenure of office of state election commissioner. So, state election commissioner, the state election commission is the commission that looks after the panchayat and municipal and various other local body elections within a state. So the governor also appoints the chairman and members of the State Public Service Commission. But please note that the governor has the power to appoint. He does not have the power to remove the chairman or the members, that power lies with the president. The governor can also seek any information relating to the administration of the affairs of the state and proposals for legislation. Though in the state there might be different kinds of proposals for different types of legislations, right? So ultimately, once the bill is passed by the legislative assembly or the council, it goes to the governor for assent, just like how a bill goes to the president from the parliament for assent. So he can seek any information regarding the affairs of the state or such proposals for legislation. He can also require the chief minister to submit for consideration of the council of ministers any matter on which a decision has been taken by one of the ministers but it has not been considered by the council of ministers. He can also recommend the imposition of constitutional emergency in a state of the president. This is a very important power. So, presidential rule cannot be imposed in a state unless a proposal to that effect, saying that the constitutional machinery in the state has been failed, is made by the governor to the president. And during the period of such presidential rule, the governor enjoys extensive executive power as an agent of the president. So that's a very important executive power that the governor has. The governor also acts as the chancellor of universities in the state and he also appoints vice chancellors in such universities. So far we discussed the executive powers of the governor. Now let's move on to the legislative powers of the governor. So just like under the union executive, the president has the power to summon or prorogue each house of the parliament. The governor also has the power to summon or prorogue each house of the state legislature. So summoning is the act of calling upon members of the house for a session, whereas prorogue, the power of prorogue is the power to bring such session to an end. So the governor has the power to commence a session of the state legislature as well as to bring it to an end. The governor also has the power to dissolve the state assembly. This is a very important legislative power that the governor has. So dissolution of the state could be because of multiple reasons. It could be unconstitutional way of functioning of the state assembly. It could be emergency. It could be war. So there could be various reasons. Both of these powers, the power to summon, prorogue and dissolve the state assembly is provided under Article 174 of the Constitution. The governor also has the power to address state legislature at the commencement of the first session after each general election and the first session of each year. So, the first session of the state legislature after the election will be addressed by the governor. Similarly, the first session of each year will also be addressed by the governor. The next power of the governor is regarding sending messages to state legislatures regarding pending bills. So this power is very similar to that of the president under Article 86. So a governor can send messages to either house of the state legislature with respect to a bill that is pending in the legislature, and he also can send messages for other reasons as well. The next power of the governor is the power to appoint any member of the state legislative assembly to preside over its proceedings when the offices of both the speaker and the deputy speaker fall vacant to perform the duties of the speaker. So if both the speaker and the deputy speaker of the state legislative assembly, both these offices are vacant, then the governor can appoint any of the member from the state legislative assembly to perform the duties of the speaker. Similarly, he can appoint any member of the state legislative council to preside over its proceedings when both offices of the chairman and the deputy chairman fall vacant. Continuing with the legislative powers of the governor. So as we must have studied in the Union Executive that the president has the power to nominate 12 members to the Rajya Sabha. These are members who have excelled in various fields such as arts, literature, sciences, etc. The governor of a state also has the power to nominate 1/6 members of the state legislative council. So if the state legislative council has 60 members, 10 of those members will be nominated by the governor. The governor can also nominate one member to the state legislative assembly from the Anglo-Indian community. A very important power that governor has is with respect to the disqualification of members of state legislature. So the governor decides on the question of disqualification of a member from the state legislature in consultation with the election commission. So the next legislative power is with respect to passing of bills. So once a bill is passed by the state legislature, it will go to the governor, and the governor has three options. One, he can give assent to the bill. Second, he can withhold his assent to the bill. Third, he can return the bill, but he won't be able to return the bill if it's a money bill. So that's a limitation to the legislative powers of the governor. Why would he return the bill? If he feels that some kind of an amendment shall be introduced in that particular bill, so with such comments he can return the bill, and if there are such comments, then the house of the state legislature is supposed to reconsider that bill accordingly. Now after this, suppose he sends back the bill, after that the bill is once again passed by the legislature with or without such amendments. At the second stage, the governor does not have the option to not give the assent. He'll have to give the assent. But there are some situations in which governor can reserve the bill for the consideration of the president. And one of such instances where he has to do this mandatorily is if the bill passed by the state legislature endangers the position of the state high court. And the most important legislative power of the governor is that he can promulgate ordinances when the state's legislature is not in session. So these ordinances must be approved by the state legislature within 6 weeks from its reassembly, and he can also withdraw an ordinance at any time. Moving on to the financial powers of the governor. These are pretty self-explanatory. So firstly, he will ensure that the annual financial statement, which is a state budget, is laid before the state legislature. Secondly, as per Article 199, money bills can be introduced in the state legislature only with the prior recommendation of the governor. No demand for a grant can be made except on his recommendation. So grants are what? Financial aids. So there are several activities in a state and you would require some sort of financial aid or a grant for these activities. So none of those grants can be made except on the recommendation of the governor. The governor can also make advances out of contingency fund of the state to meet any unforeseen expenditure. So contingency funds, say there is a natural calamity or a disaster. So the governor can make advances out of the contingency fund to meet such unforeseen expenditure. The governor also constitutes a finance commission every 5 years to review the financial position of the panchayats and the municipalities. So these are the financial powers of the governor. Next, we will look into the judicial powers of the governor. Just like the President of India, the governor also has the power to grant pardon, reprieves, respites or remissions. He can also suspend, remit or commute sentence of any person convicted of any offence. But please note that he does not have any power to pardon death sentence. Only the President can do so, and the President can even pardon sentences given by military courts, but the governor cannot. Another judicial power of the governor is that he is consulted by the president while appointing the judges of concerned state high court, and the governor make appointments, postings and promotions of the district judge in consultation with the state high court. He also appoints persons to the judicial services of the state other than the district judge in consultation with the state high court and the state public service commissions. So these are the judicial powers of the governor. Emergency power of the governor we have already discussed while we were talking about the executive powers of the governor. So governor can make a report to the president whenever he is satisfied that there is a situation arisen in the state in which the government of the state cannot be carried on in accordance with the provisions of the constitution, and can recommend presidential rule in that state. So this is the emergency power conferred upon the governor. So we discussed the executive powers, the financial powers, the legislative powers, judicial powers, and the emergency powers of the governor. With that, we will move on to the next part of the state executive, which is the chief minister and the council of ministers. So, Article 163 of the Constitution states that there shall be a council of ministers headed by the chief minister in each state. So, the qualifications to be a chief minister are: firstly, he shall be a citizen of India; secondly, he should be 25 years of age or above, and should be a member of either house of state legislature. So, very briefly, let's look into the powers and functions of the Chief Minister. Chief Minister is considered as the real executive head of the state and holds absolute power. So, this is the same as in the case of the President and the Prime Minister. The Governor here is considered as a nominal executive head, whereas the Chief Minister is considered as a real executive head. He is the working head of the state, and he presides over meeting of the Council of Ministers and ensures the principle of collective responsibility. So he communicates all decisions of Council of Ministers, administrative affairs, and proposals of legislation to the governor when called for. He is a channel of communication between the governor and his ministers. So essentially, he is the middleman. Whatever decisions the Council of Ministers have taken, he will inform that to the governor, and whatever the governor wants to communicate to the Council of Ministers, he'll communicate that to the Council of Ministers. So essentially, he is the middleman. The Chief Minister is also consulted for appointment of state high court judges and the State Public Service Commission. Moving on to the next part of the state executive, which is the Council of Ministers. So the Council of Ministers in the state is constituted and function in the same way as the Council of Ministers at the center. So the Chief Minister is appointed by the governor, whereas the Council of Ministers are also appointed by the governor, but on the advice of the Chief Minister. So only those persons who are recommended by the Chief Minister can become part of the Council of Ministers. The qualifications to become a Council of Minister: firstly, he shall be a citizen of India; secondly, he shall be of 25 years of age or above. He should be a member of either house of the state legislature. However, non-members can be appointed in the Council of Ministers provided they must become a member of legislature within 6 months, and if they fail to do so, then this person will have to forfeit his office. Council of Ministers, with the Chief Minister as the head, is there to aid and advise the governor in the exercise of his functions. The Council of Ministers formulate and shape policies. There are different kinds of policies in the state. There is health policy, there are education policies. So there are different kinds of policies. So these policies are formulated and shaped by the Council of Ministers. They also initiate legislation. Whatever legislation is passed by a state, most of them are initiated by the Council of Ministers. You must have seen how a member of the state legislature, especially who is a minister, is proposing a particular legislation or an amendment to an existing legislation. The Council of Ministers also coordinate the work of various government agencies, and very important for the course, the public administration of a state is guided, directed, and controlled by the Council of Ministers. The last part of the state executive is the Advocate General. He is the highest law officer in the state. So this post corresponds to the Attorney General of India. The Advocate General is appointed by the governor. He must be a person who is qualified to be the judge of a high court. So in other words, he must be a citizen of India and must have held a judicial office for 10 years or have been an advocate of a high court for 10 years. The Constitution does not fix any term of office of the Advocate General. It also does not provide any procedure or grounds for the removal of Advocate General from his office. It only says that he holds office during the pleasure of the governor. So this is all about state executive. We dealt in detail with respect to the governor, especially the powers of the governor, because that is the most important post. And then there is Chief Minister, Council of Ministers, and Advocate General.